We're live on Facebook. I'll start broadcasting for the Zoom webinar as well. We'll take up a moment to reach the maximum number of attendees, then we'll start. So I guess we've reached the maximum number of participants here. The rest of the participants will be redirected to our Facebook pages, so they can see live there. First of all, a very good morning, a very good afternoon, a very good evening for everyone across the world. And I warmly welcome Ms. Nikila, Ms. Madeline, Kimei, and Mr. Inbavijayan for this webinar, which KFCRI is hosting. Before we start on with this webinar, I would like to give a brief introduction on what KFCRI is. Kovise Foundation Conflict Resolution International is majorly part of two wings. One is it is an accrediting body. That is, it provides accreditation in various fields of arbitration, mediation, conciliation, negotiation, and even how to be a tribunal secretary as well. Apart from this, its other wing is that it is an ADR institution in itself, meaning it has its own rules in, again, all the fields of ADR, and it has clauses which can be incorporated into various contracts. If any dispute arises out of such contracts, it will be adjudicated by this institution to the medium necessary. So before we start again with this webinar, I would like to establish a few housekeeping rules. Down below, the attendees can see the Q&A box. During the course of the webinar, you can please type out your questions in the Q&A box and submit it there. We'll be answering it in the last 15 minutes, which has been allocated for the Q&A. Any unanswered questions can be emailed to kfcri.adr@gmail.com. We'll try our best to answer. With this, I would like to invite Mr. Inbavijayan to introduce the speaker. Thank you.
Thank you, Swetha. Welcome, Madeline. Very interestingly, she is a very prominent arbitration practitioner in Tanzania. I think for better understanding for many audience, particularly from India, she's a very active practitioner, and she has been considered as the president of Tanzania Institute of Arbitrators. To add on, she is also the president of the Africa-Asia Mediation Association, wherein initially I was also intended to join, but anyway, in future I might join and actively promote that organization. She also is considered as a member from Tanzania for the ICC International Court of Arbitration, one of the oldest and long-standing arbitration institution which actually administer international arbitrations. To comfortably consider for today's topic, which is on ODR, or a virtual arbitration Africa, she herself run a very effective platform for online dispute resolution, which is called iResolve. And she's very, very active in online dispute resolution, not only in Africa, globally. And we take this opportunity to welcome you for this webinar series. Particularly, this is the first one we are reaching the African market, and we are very happy to invite you. Thank you. And now I'll hand it over to M.Sri Nikila.
Thank you, Mr. Inbavijayan and Mr. Shwedan. Ms. Madeline, it's a great pleasure for myself and my team to have you as a lead panelist in this webinar session on virtual arbitration, or ODR, in Africa. Without wasting much time, I would like to right away start the session. Since our attendees are from different parts of the world, my first question to you would be, what is the current stage of ODR in Africa? And also, with the outbreak of COVID-19 pandemic, what future does ODR hold in Africa?
Thank you, Ms. Nikila. Thank you so much. And a special very warm thanks to Mr. V.Inbavijayan for his introductory remarks. And of course, having introduced me in such a wonderful way. Thank you so much. It is a pleasure to have a friend of mine have me today on this webinar to discuss the issue of ODR and virtual ADR in Africa and of course worldwide, as he has said. Yes, my work at iResolve, which started in 2015, is really what got me interested in developing the space of online dispute resolution, and with the encouragement from persons who I look up to, such as Mr. V.Inbavijayan and the team that I have with me at the Africa-Asia Mediation Association. That support really gives it much more of a unified sort of approach to developing capacity within this field, not only in Africa, but also internationally. So thank you so much for the opportunity. Now, just to go straight to the crux of the question that Nikila has shot to me, the current stage of ODR. Before I go to that, maybe we could explore as to what ODR is. ODR it grows from the stem of alternative dispute resolution. And the spectrum of alternative dispute resolution, we all know, includes the mechanisms such as mediation, arbitration, negotiation, and the likes. Now, with ODR, this takes the form of an online or more, it is assisted by the use of technology. And this, there's a term that a book written by Professor Abdul Muhammad Wahab, Catch and Rainey. It's a 2012 edition. And they say that ODR is a form of online settlement that uses alternative methods for dispute resolution. The term covers disputes that are partially or fully settled over the internet, over the use of the World Wide Web. Now, this includes, of course, the cyberspace. Some people refer to cyberspace, and it could be also an offline sort of a platform, which is maybe attached to our phones and so on and so forth. Now, it's not a new field as well. This has developed over the past 20 years. We've had the expansion of ODR and digitization of these particular mechanisms that we all know traditionally as alternative dispute resolution mechanisms. And of course, if we look onto our judges and the bar associations in our respective countries, or councils and attorneys, all are confronting this shift or this shift to the use of technology, because we want to shrink the cost of litigation. We want to increase the access to justice, and technology is something that needs to be embraced in order for that access to justice gap to be reduced. And so that's just an introductory remark to what ODR means to the societies that we live in, and especially in Africa, where not a lot of people, maybe the percentum rate, if I could refer to a percent, is less than 10% that have access to justice. So the current stage, it's good to be very open and truthful about the situation. And in developing countries and in Africa, of course, we say that we're still developing. We have not pioneered in the field of ODR. ODR has sort of gone off a long way, whereas Africa is still lagging behind in its development of ODR platforms, ODR solutions to the provision or the offering of mediation and arbitration and other alternative dispute resolution mechanisms using technology. Why is this the case? Well, the problem could be coming from the challenge that we all face in certain jurisdictions, and that is the change in law takes too long. You know, our parliamentarians will be sitting on the need for a law that would enable the advancement of such use of technology on dispute resolution, but that takes a long while for it to take effect. And so therefore, we found ourselves sort of just, you know, at the back of the line. Now, another issue that is a challenge, and that's why we're at this current stage of ODR in Africa, is the ability of the use and the application of such mechanisms, of the technology that could be out there. For example, iResolve. Now, for lawyers or practitioners to be able to use the platform, they need to learn how to use the platform. They need to be willing to learn to use the platform. Otherwise, it won't pick up. And so we find ourselves lagging behind because also of the fact that we don't have the technical know-how. And in addition to the current stage of ODR in Africa would be the fear for poor data protection and security of confidential information. And I think we'll talk about it more in later on in our discussion. Another issue is the cultural challenges that we face. You know, arbitrators that are groomed arbitrators are those who are elderly. And you find when you pose to them as counsel that, okay, let's use Zoom to conduct a virtual hearing, they are resistant to that change because of the inability, one, and the unwillingness to do so. Some arbitrators would say, I prefer face-to-face, and we'll talk about this later on in our conversation. So there are a lot of challenges challenging the current state of ODR in Africa. We have not shifted, but to your follow-up question on what has happened recently now with the outbreak of this coronavirus COVID-19 pandemic. Now, this pandemic has really changed the mindset of a lot of people, the mindset of even the most resistant of all resistant people, because now we are forced to embrace technology. We are forced with no other option to do e-filing of our written submissions in our courts of law. We find that our chief justices across the globe, I've read the Australians and the Singaporeans and the English, all coming up with instructions to counsels or lawyers who are litigants to use the electronic filing systems that their courts currently have in place. Not only are we not seeing also judges taking platforms such as Skype and Zoom to deliver judgments. And so, you know, because the delivery of judgment is really just the parties showing up in front of the judge, and the judge would read the judgment to you, and that is it. You would get a copy of the judgment afterwards. And so the need to go to court and putting yourself at a health risk is minimized through the use of technology. So the opportunities presented by the COVID-19 will significantly change ODR and the way we see it. That is the statement that can be not called into question at this point in time. And back in 1998, if we go to what Nicholas Negroponte predicted and declared, he said digitalness would just become part of the wallpaper. Its literal form, the technology, is already beginning to be taken for granted. And its connotation will become tomorrow's commercial and cultural composite for new ideas. Like air and drinking water, being digital will be noticed only by its absence, not its presence. Now, this is really, the situation we're in. The absence of having such technology in place for us to be able to carry on our work is when we realize the importance of it all. And so COVID as Africa to leapfrog, because we've had to leapfrog. We had to react overnight and take on the technical logical evolution and break down the walls and say to the parties, you have little option but to go virtual. And so I think that's why I would leave it to, so that Nikila can proceed on with our engagement. Yes.
Okay, ma'am. Apparently, with opportunities being increased for ODR, my next question to you would be, what degree of willingness does the parties of the dispute resolution process are exhibiting towards ODR?
Thank you so much for unmuting me. I had put myself on mute so that we could hear your question loud and clear. And the degree of, if I could go right to it, the degree of willingness the participants of a dispute resolution process towards ODR, you know, from my key points as to why we're lagging behind, it's the great example that works, and it has been proven to work, is the World International Intellectual Property Organization success story. They have a great platform solving domain name disputes, and willing to use that platform. Everything is conducted online. There are no face-to-face meetings, and in very, very, very unusual times, you would find domain names handled face-to-face. Really, this success story and something we should look into and learn from. The WIPO uniform domain name dispute resolution way of approaching online disputes. Now, with that said, how willing are the parties to go to ODR? When left with no choice, they'll proceed to ODR. They'll proceed to use virtual hearing for their arbitration hearing that was scheduled, but due to the coronavirus, unfortunately, the tribunal cannot fly out of their countries. This is an international arbitration. The expert witnesses and the fact witnesses are unable to meet at one meeting place with the tribunal in order for them to be to conduct the hearing. And so, as I said, COVID-19 has left us with no choice. But all in all, it is not just what is happening right now. Even before coronavirus, we have had virtual hearings happen for those fact witnesses who are unable to, for example, secure a visa to go to a particular arbitration hearing. And so the arbitral tribunal are able to accommodate that fact witness by using video conferencing. And so their willingness at this point, I would say, the participants themselves find it to be much more cost effective and much more efficient in the manner that we see the ODR assists in the process of dispute resolution. Of course, if we go now to the advantages of ODR, if the counsel responsible for that disputes to be resolved explains to the participants, explains to the stakeholders the advantages attached to online dispute resolution, the parties would sort of break down their negativity towards the process, because usually the fear, and we'll talk about this more during our chat, is trust. Do we trust this system? Is the information that we're going to be exchanging going to be secure? Is there going to be any cyber issues, cyber hacking, or is the platform having the right security features for me to be able to conduct a mediation over an IP dispute over such a platform and not lose my trade secrets? So these are the challenges that you have in obtaining that party to be willing and able to participate in an ODR process. Yes, Nikila.
Yeah, so more than willingness, it comes to no other way when it's with this outbreak of pandemic and we have to go for ADR. So with parties being willing, or it's rather an involuntary process, my next question is, what is the statutory position of ODR in Africa?
That is a broad and right now are online. Is it left to self-regulation? This is a question that one can dwell into, and there are many schools of thought. You know, self-regulation is much more possible in the sense accommodative of situations. Stringent approach could hinder its development. Now, those are different schools of, but the UNICITRAL issued technical in 2017 dispute resolution, and these were not you know, say at the preamble of these technical notes that this is a non-binding document.
Ma'am, sorry to interrupt you, but we couldn't hear. I think there is some technological glitch in our Zoom meeting. She will reconnect us shortly.
I'm so sorry. I think I fell off.
That's okay, ma'am.
I fell off the radar there. Technology took the best of me, and I do apologize to all participants for having had that hiccup. I'm not sure what went wrong. It could be my network, but also it could be my flimsy hands. Maybe it could have been a slip of the hand. I apologize for that. And as I was saying, because I ended up talking to myself for a few minutes. So what I was saying was that the UNICITRAL technical notes are providing more of a guidance to the online dispute resolution portals and administrators and providers and users and practitioners of ODR. And so they're non-binding in nature and not exhaustive as well. If you go on to see what paragraph 6 of that technical note says. And then you other sources of online dispute resolution or embracing that mechanism would be the New York Convention on the recognition of enforcement of foreign arbitral awards, and the Unicitral Model Law on International Commercial Arbitration, which both take into account electronic formats of conducting arbitration and the enforceability aspect of these electronic forms of or transmissions that may take place by the use of course, ODR. And I think that's really what I would like to say on statutory positions. In Tanzania in, for example, in Tanzania, what we can see also is the Electronic Evidence Act, Electronic Transactions Act, and then our Evidence Act was amplified a couple of years ago in 2008, if I'm not mistaken, where we now recognized electronic evidence. And so all these measures that have been taken by the legislature, including our new Arbitration Act, which was enacted in 2020, February, which have provisions for electronic means of engaging with your tribunal, engaging within the arbitration, that enable now parties to say, okay, let's go to online dispute resolution. The law seems to be taking root that way, and technology seems to be something that could not be of a challenge later on in the process.
I hope ODR finds way in its position in its statute. My next question to you would be, what is your view on the customary saying face-to-face arbitration is much effective than virtual arbitration?
Thank you, Nikila. So this has been a very big concern. And there are different schools of thought as well when it comes to the impersonalized sort of, or that disconnect between the tribunal or the mediator and the actual persons that are involved, the parties, the witnesses, the experts, and the counsels themselves. Because now this is where your advocacy skills also are challenged as a counsel, because you're conducting the arbitration hearing on an online platform. You have to cross-examine on an online platform. And so all these aspects of an arbitration becomes much more complacent as opposed to a face-to-face arbitration, where the usual traditional advocacy skills work well. Now, the lack of personal interaction, some may say, it may reduce the chances of settlement if it was a mediation. This is it's called the face theory by Goffman. And Goffman says that this could hinder settlement in a mediation. Now, in the customary arbitration, which is what we're looking at, the virtual hearing of an arbitration, the personal connection, the body language, the verbal cues of the witness, it's very important to an arbitrator. And certain arbitrators would say they form part of the process and very important in them reaching their conclusions on various aspects of the case. And also, when you consider the complexity and the nature of the case, especially if the nature of the case touches on issues of fraud or issues of mistrust and things which are needing to be proven, and that is where the challenge comes, because on an online virtual hearing, really the disconnect. We're not facing each other. There is a border that is sort of could hide certain issues from the arbitrators and the other parties who cannot see what is going on. So it's less of a humanized process, and these have been views that have been put forward because the arbitrator has less control over the process as opposed to a face-to-face arbitration. And moving online, some say, may help sort of diffuse certain tensions. So some cases may be good for virtual arbitration, for virtual hearing, because it could diffuse that tension that you have, as opposed to meeting one person face to face and being so angry. And you know, face to face is much more easier for you to react in a manner that you would not wish to react, as opposed to being online. Because here, if I react from this end, you would really not get the harm that I want you to get. So it's a different kind of playing field. But this is an issue that each tribunal decides on the case-to-case basis, whether the virtual hearing would suffice. And for an arbitrator, if I was an arbitrator, if the matter has issues of fraud or of presentation of documentation, then I would rather have that be a physical arbitration as opposed to a virtual arbitration. Yes, Nikila.
Yeah, so virtual arbitration having its own advantages and disadvantages. I would like to ask you, what are the ethical principles available in ODR?
The ethical principles evolving around ODR really relate to enhancement of the ODR, the quality, the effectiveness, and the scope of dispute resolution process employing technology. How do you enhance this? And so these ethical principles really look into enhancing that deployment of technology for the effectiveness of the process and the quality. So one key ethical principle would be remaining to be neutrality. So an ODR system or practitioner or whatever used platform, it would have to be independent from the disputing parties. That neutrality would have to be checked by conflict of interest checks as well for transparency. Another key ethical principle would be accountability of that ODR platform or system. Accountability in the sense that those institutions or legal firms that provide for ODR systems know that they're serving their community and they are accountable to the service that they provide. And also the principle, I go back to confidentiality, because confidentiality is the key element that makes alternative dispute resolution so strong, have so much strength over other processes. The confidence that parties have that their information shared would not be disclosed in any later proceedings, or will only be disclosed upon their consent to disclose, or of course by operation of the law. If we're in a common law jurisdiction, there are those exceptions that we know of. Now, with confidentiality, now the ethical principle there is that the ODR system that is in place, or the process, should be able to maintain confidentiality in accordance with the legal obligations, and in the manner that are consistent with the principles of legal obligation, informed participation, security, and transparency. Now, all these ethical principles such as fairness, honesty, and impartiality all come into that same parcel of ensuring that there is a quality and effective ODR system in place, that parties can also be willing enough to agree to use such ODR. So fairness, honesty, and impartiality of that ODR platform and provision is very important for there to be buy-in by the participants. Buy-in by the participants always works where those ethics are being observed and are being carried out. Now, you know, I read I have this book called by Katch and Rifkin, and they say the important factors. There are three important factors that form the essence of ODR, and those three important factors are convenience, trust, and expertise. So having that ODR system being convenient, trustworthy to use, and expertise. And when they say expertise, is being able to use it with ease. I mean, those who are offering it have the expertise to offer it, yeah. And the convenience is being able to use it with ease. It's convenient for me to use it, and so I'm easily able to access it because it's a convenient solution to my situation. And so the principles really work hand in hand with what the essence of ODR is.
Thank you, ma'am. That was a delightful insight. With confidentiality and transparency being the ethical principles of ODR, do you think it can be efficiently maintained in an ODR process?
Yes, so with witness coaching, it's a different playing game, because it's a very difficult situation where you have the arbitrator having to take fact witness testimony via a virtual hearing. You cannot control what is happening on the other side. Now, what they have done over the past few years, and I think most recently, we've seen the Chartered Institute of Arbitrators issue guidelines on remote dispute resolution proceedings sometime in April or late March 2020, just after the COVID-19 outbreak. Where these guidance notes, at 3.1 of that guidance note, they state that the use of commercial digital platforms and for us now to preserve that there is no tampering of the witness, or the witness is not being coached, or the witness is not under undue influence. You must use a commercial digital platform, yeah, and which can be equipped to create an atmosphere approximating face-to-face proceedings, and all participants should be visible. They should be visible and audible in a chosen virtual hearing room. Now, yes, the guidance notes would provide that, but in reality, how would you make sure that this atmosphere that they're saying has to be created as if it was a normal situation? So the virtual realities will not be the same. If we look at the ICC, for example, they also have a checklist, and what they say, there has to be a 360 camera view. Now, a 360 camera view will enable the tribunal to see around my room. Now, even and say that before the tribunal hearing the witness, the room needs to be identified. The witness needs to sort of have a 360 view of his room to show the tribunal that there is nobody in the room. On to the sole protocol on video conferencing in international arbitration. This was the sole protocol which was in place since, I think, last year. And they also suggest for a 360 room view under their Article 1.2. Then they provide for that there has to be a specific hearing venue or a remote venue that is approved by all parties, and an observer or a circulated list of participants, so that they are aware who is where and who is attending the hearing, and nobody is coaching or tampering with the witness. And so there's so many guidelines that have approached this issue in a different way. But at the end of the day, it is really back to the tribunal and the arbitrator. Because as the arbitrator, I would have to very much be at attention to make sure that the witness, his facial expressions are not, inconsistent with what he's saying. Because if he's being coached, then he'll be listening to someone yet along, or looking at his phone because he's receiving information to disclose or to testify, which is it's a very big challenge. But with measures that have been put in place with different guidelines that I have stipulated, the SOL protocol, the ICC checklist, the Chartered Institute of Arbitrators, and several other institutions, they provide for guidance, but of course, the challenge still remains to be there.
So we are almost out of time. I would just like to ask you some 2 or 3 questions in rapid timing. With witness coaching being a greater menace in ODR, what do you think there are which other implications in implementing an effective ODR process?
Well, other implications in implementing the ODR processes would be, well, the key to success is the ability to use and be able to be comfortable with technology. And the other key implication is having cooperation between all parties, the tribunal, and the representatives. Very crucial for there to be an effective ODR process. For that process to be effective, cooperation is at the utmost of importance. Now, not only is there cooperation and ability and comfortability of the technology, but there has to be consent. And if you look at the UNICITRAL technical notes, they specifically state that consent has to be expressed by the parties, that they consent to the use of the ODR process that is being used. If we refer to the new issued Africa Arbitration Academy protocol on virtual hearings in Africa, there they have provided a pre-hearing, a pre-virtual hearing agreement. So that's a new invention where that protocol says, okay, so you're going to go into a virtual hearing. This arbitration was already pending. There was no agreement as to the use of technology. That agreement, when you reach the consensus that, okay, actually we have to go to virtual, you have to have an agreement in place that reflects what has been agreed by the parties. And so these are the other implications that one needs to take into account. And if I could add on to that, the other implication, of course, is the choice of the platform or the choice of the ODR provider. This is very crucial because, for example, with the ICSID, they prefer the use of WebEx. Why do they prefer the use of WebEx? WebEx has end-to-end encryption. The security features are strong, and the security features are acceptable to that organization. So then now also other institutions worldwide would need to accommodate the platforms that they feel have the security features to the levels that could sort of reduce the risk of data leakage and release of information or breach of confidentiality. Yes, Nikila.
So finally, I will just ask you one last question. Seat of arbitration clause is significant one in traditional arbitration. Do you think what impact does a seat of arbitration clause make in ODR? It is positive, or it is again an implication in an ODR process?
Well, it's a tricky question, and it's a good question as well, because it's very difficult to determine the seat of online arbitration. We're not at this point. Of course, we can talk about e-commerce and its intricacies, or we can talk about offline arbitration, where you have an arbitration agreement which has a seat allocated, and they've agreed on the seat, and they've agreed on the governing law and applicable law accordingly. Now, the parties are usually free to choose the seat of arbitration, or they just have, if they haven't agreed, the arbitral tribunal, in the absence of agreement, the arbitral tribunal could then decide upon on the issue of the seat. Now, with online arbitration, you cannot completely ignore the requirement of traditional laws. You cannot ignore the requirement of the traditional laws that are applicable to that arbitration. If the arbitration procedure is not in accordance with the parties' agreement or accordance with the law of the country where the arbitration took place, its enforcement can be refused. So there's that risk factor attached to where you find that there's an issue with the law applicable to that arbitration. However, I would say where there's the choice is missing, there's no institution that which might well happen in an online arbitration, and the place of arbitration is not known, the validity of an online arbitration will certainly be called into question under the New York Convention. And so I would go back to the drafting of the clause, and ensuring that the drafting of the clause is well curated, in the sense that it captures the issue of the seat that is applicable to that arbitration. And so that ODR process will then be pegged to that agreed seat, or if not agreed, then the arbitral tribunal who decides upon the issue of the seat that they decide upon would be the seat that would be applicable in that particular ODR process.
The question and answer box is popping up with lots of questions. Shall we start with the question and answer session, ma'am?
Yes, sure.
Yeah, so it's a rather interesting question coming up from Mr. Ishan. He is asking how to convince party to rely on ODR for their complex disputes.
Sorry?
I will repeat, ma'am. How to convince parties to rely on ODR for their complex disputes.
In a complex dispute?
Yes, ma'am.
So the use of ODR in a complex dispute, it really does come about, as I said earlier, on a case-to-case basis, where you assess your case. And as a counsel, if you're counseled in a particular arbitration that is a complex arbitration, you'd be able to strategize and say to yourself, you have a strong case, and your strategy and roadmap to that case looks a bit like this. And if we use ODR, it could either break my case or be okay for my case, for my party to get the solution that they need to get. But at this pivotal moment in time, where we have the health risk of COVID-19, we also have to look at the risk factor as opposed to our health, as opposed to the complexity of the matter. So you find that even complex cases with a lot of documentation, very document-intensive cases, are being conducted online with 7-hour, over 5 days, 7-hour hearings on an online platform. And so that is a complex case, I would say, where you have so many witnesses situated in different countries, and it doesn't have to be different countries. It could be within India itself, or within Tanzania, in my case. But meeting be a health risk. And so for the complexity of the matter vis-a-vis your health, that sort of weighs down the scale. But yes, the question is very important, because you need to go and delve down into your case and understand the case that you have and the complexities around it. And as I say, if it's a matter that involves issues of fraud and the likes, then virtual hearing might not be very conducive to that kind of nature of case.
Thank you, ma'am. Rather a personal question have been asked by Ms. Sai. She is asking, have you handled any matter online in this COVID-19 period? If yes, how was the experience?
Thank you so much for that question. It's good to come back to what I've done now. Um, for us here is that I currently have two pending arbitrations, and I've got one adjudication. So what happens is that in one matter, I've had to arrange for a WhatsApp group call uh, for the lawyers to address me on an issue that was raised with respect to that matter. So yes, I've had to go my way to use WhatsApp. I've also had to go my way to use Zoom and Microsoft Teams. So these are all platforms which are they've got good security features. The challenge comes about when you have a lawyer who has never used the system, these platforms. So if a lawyer has never used Zoom, you send him the invitation, they won't know what to do. They don't know what to click. And it ends up being like me previously when I dropped off. So, so I try to use the most accessible form of electronic communication with my parties. So if WhatsApp was the only way for me to get them into one conversation together with me, because you cannot do an ex parte discussion, then it worked well, and we spoke and arranged for another meeting. So for me, it works well. And because of this COVID-19, and I think I would be taking it on even moving forward, because some meetings are not requiring you to always call them to your office, prepare for them tea, water and drinks and so on and so forth. You could just give them a call and ensure that everyone is in a place where it's secure, that whatever we're discussing is not being heard with anyone else, and that they are willing to participate in that call, because sometimes the counsels could be difficult counsels who don't want to hear anything to do with such technology. They want a physical meeting. They find that the physical meeting will be more effective than the telephone call. Yes.
Thank you, ma'am. The next question is from Mr. Amit Shah. He is asking, has Tanzania established its arbitration center under the new legislation? And if so, how it is dealing with ODR?
Sorry, which new legislation?
I'm not sure. He is just asked under new legislation.
Uh-huh. Well, if I could speak for the country that I'm in, we have a new legislation, yes. We have a recent Arbitration Act, which was passed by Parliament in February 2020 and assented and gazetted in 21st of February 2020. This legal the law on arbitration is pretty much aligned to the United Kingdom Arbitration Act of 1996. But it's gone a long way to also accommodate other provisions that are more accommodative of the situation in Tanzania. And along with that, it has recognized electronic transmissions, electronic writing agreements in writing of arbitration agreements, and electronic signatures, and documentations being transmitted electronically to the tribunal. All those have been recognized as forms that are acceptable. And so therefore, I would say the new legislation does embrace technology. It does take into account that this is where we're going at that point. But now we're here already, because we now are with the impact of this coronavirus, we are now at the future that we used to say we're going to. We're there now. We have no other choice but to implement it.
Thank you, ma'am. That perfectly answers the question. The next question is from Mr. Janaki Raman. He is asking whether arbitration clause expressly allowing online arbitration is mandatory for initiating cyber arbitration, or simple arbitration clause itself is enough.
That's a very good question. There are smart contracts. These smart contracts are a form of contracts that are done electronically. It's some sort of a blockchain effect, where that smart contract will entail a dispute resolution clause or an arbitration clause that would provide for online arbitration. Now, in the conventional arbitration agreement, where you have a contract in place, that is a contract for the sale of goods, for example, and there is an arbitration clause to that effect, then yes, ODR can take part, or ODR can be implemented over that arbitration. It's because it's a procedural issue. So when you sit with your tribunal and you're setting out your procedural timeline or your procedural agreement with the tribunal, at the outset, you can inform the tribunal that for one, a documents-only arbitration, where you will be transmitting the documents to the arbitrator, and the arbitrator will decide upon that dispute by the use of the documents that you have transmitted. Now, or you could agree to the fact that, okay, there will be a hearing. However, we wish this hearing to take place via a virtual platform. And this is all in agreement between the parties and the tribunal. And once that is agreed, they will then apply the rules that they wish to apply, similar to the rules that we apply, for example, the institutional rules, or the IBA rules on taking on evidence on international arbitration. Those rules could also include the rules of conducting virtual hearings, that we will take the guidance notes of the ICC to assist us in carrying out the virtual hearing. And so, no, it does not have to be on the face value of the clause. It doesn't also have to be something that you've already agreed upon. This could be agreed upon after the event. It doesn't have to be agreed upon at the beginning when you're drafting your contract. But only a futuristic lawyer envision that they will do a virtual hearing. So maybe, those futuristic lawyers could be very creative in creating a very good clause that would, that would sort of take into account situations where if the tribunal is unable to meet face to face, a virtual hearing would suffice. Yeah. So that is, it's not very, it's highly encouraged, highly encouraged.
That perfectly answers the question, ma'am. Unfortunately, we are at the end of the session. I would like to extend my heartfelt thanks for your valuable dedication of thoughts and time to us. Apparently, it's impossible for anyone to move to Africa physically at these tough times, but undoubtedly, you had taken us all, at least mentally, to the African continent with all your valuable thoughts and insights, ma'am. Thank you so much for a wonderful session. Now, I would like to leave the platform to Mr. V.Inbavijayan to give the concluding remarks.
Thank you, Nikila. Thank you so much.
Thank you, Madeline. It was really an interesting session on ODR. And I think there were a few audience who are actually who are involved in mediations were there facilitating whatever answers you also guided. And it was really an eye-opener for many of us, particularly the traditional arbitrators. We have to be ready to take ODR. Otherwise, we as arbitrators are going to lose our opportunities. That is very clear. We have to be ready. And one small thing I want to add on, or I want to get information from you regarding this Singapore Convention on Mediation, whether this new convention is also facilitating the online mediation process.
Thank you. Thank you, Mr. Babajan. Thank you so much. And you touch on a very important aspect of ADR because of the new developments that we see that came about with the Singapore Convention. It was a crucial turning point for ADR practitioners and mediators, more specifically mediators. Now, with the Singapore Convention, as you mentioned, it really gives it gives the mediated settlement agreement the enforceability sort of push that has been attached to arbitration with the New York Convention on the enforcement and recognition of foreign awards. Now, with this advent of the Singapore Convention, online dispute resolution is much more now required to be embraced. With mediation being it online mediation has been proven to be very successful, and it's something that has picked up more than arbitration. With arbitration, it was a reluctant. There was a reluctancy to it because of the aspect of the adversarial nature of arbitration. But when we look at the online mediation, it was much more easier to transition to ODR and the use of technology, because with online mediation, the traditional aspects of mediation do not change a lot. The flexibility remains, the confidentiality remains if you use a platform that is well encrypted and well able to accommodate caucuses and able to accommodate breakout rooms, or caucuses. I'm not sure if we understand each other when I say caucuses. But if you use the right technology, mediation works when you use virtual solutions for you to carry out mediation. And the statistics are very positive. And I would really encourage at large mediators to proceed on to encourage parties to conduct the mediations over the internet, over the use of technology. The Singapore Convention, when it comes, when it is, of course, you have to ratify it and municipalize it into your local legislation, but it does give it a very big push that ODR should be something that we should all look into in ensuring that international commercial mediation takes place effectively and cost efficiently.
Madeline, we will take it. ODR is the future. I think it's a huge thanks from KFCRI and its team for this enlightening session on virtual arbitration. And I think it is a good beginning. Whether it is going to be COVID-19 effect or any other effect, we are going to venture into ODR. Thank you. Now I'll request Swethan to just proceed.
Thank you. Thank you very much.
Thank you again, Mr. Inbavijayan. Thank you, Ms. Madeline. Thank you, Nikila. It was a really engaging session, and we are already getting responses from all around. A bit of logistics. The question, we still have a number of questions which are unanswered. We really request everyone to forward your questions to kfcri.adr@gmail.com. We will try to forward it to the speaker and answer it as much as possible. And not just in Zoom, we are getting various questions from our Facebook Live post as well. We request them also to send their questions to kfcri.adr@gmail.com. Apart from this, we have a number of webinars being arranged in the next few weeks for the May month. We will be reaching all of you via email regarding to the same. And the recorded version of this same webinar will be uploaded in the YouTube channel of KFCRI. Again, the link of which will be sent to all of you via mail. I thank everyone for attending this session, especially the KFCRI team who's been working behind the curtains as well. Thank you, everyone. Thank you.
Thank you.
Thank you.